Good evening, and welcome to the Zoning Board of Appeals meeting of Wednesday, September 25th, 2024. At this time, I'm going to call upon everyone to stand so we can pledge allegiance to the flag. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd ask that you all remain standing in a moment of silence in honor of our soldiers, past and present. Thank you. I'd like to announce that this meeting is being recorded by Dartmouth Community Media, and also that our next regular scheduled meeting for the Board of Appeals is Wednesday, October 9th of 2024. Moving on to the public hearings portion of tonight's meeting. The first matter that we have is an administrative appeal. It is AAPL-24-1. The petitioner is attorney Michael McVeigh. The owner of the property is James Lemieux. The subject property is 96 Bryant Street, also known as map 178, lot 135. The property is located within the single residence A zoning district. It was legally advertised on September 5th of 2024 and September 12th of 2024.
I make a motion that we waive the reading of the abutters list.
Second.
All in favor?
Aye.
Aye, the ayes have it. The petitioner in this case is seeking an administrative appeal to appeal the decision of the Dartmouth Director of Inspectional Services regarding map 178, lot 135, due to it not being consistent with two previous positive buildability determinations written by Dartmouth Building Commissioners. So at this time, I think I've got a couple of letters to read into the record here. There's a denial letter here. This is a letter that was addressed to Attorney McVeigh on August 6th, and it's regarding 96 Bryant Street. It says, I've reviewed your application, and at this time, your proposal cannot be approved due to non-compliance with current zoning regulations. Owners requesting confirmation that the lot is buildable, consistent with two previous positive zoning determination letters written by former Dartmouth Building Commissioners. Please be advised that I have reviewed this information. 96 Bryant Street, map 178, lot 135, has merged with 100 Bryant Street, map 178, lot 133 for zoning purposes, and is not protected under MGL 40, section 6. The lot in question came under common ownership when Thomas H. and Helena J. Lemieux, who owned 100 Bryant Street, purchased 96 Bryant Street in 1968 and held them in common ownership until the sale of 100 Bryant Street in 1994. Based on this information, it is my opinion that 96 Bryant Street is not a buildable lot. Your application is being denied under the sections of Dartmouth zoning bylaw, and I'm not going to read the whole bylaw into effect, but it is chapter 40, section 6. So the letter goes on to say that the subject property is located in a single residence A district, and I probably should read the first part of this, and that is, any increase in area frontage, width, yard, or depth requirements of a zoning ordinance or bylaw shall not apply to a lot for single or two-family residence use, which at the time of recording or endorsement, whichever occurs sooner, was not held in common ownership with adjoining land. Conform then to then existing requirements and had less than the proposed requirement, but at least 5,000 square feet of area and 15 feet of frontage. 50. Excuse me, I said 15. It's 50 feet of frontage. And this is the provision for undersized lots that were in existence prior to. And as we all well know on this board, that in order for a lot to be buildable in a zone, single residence A zoning district, it's a 40,000 square foot lot, 150 and 150 foot of frontage. All right. So moving on, I have no other comments or letters from any other boards from the town. So at this time, I'm going to call upon the petitioner's representative to plead his case.
Thank you, Mr. Chairman. Thank you, members of the board. Mike McVeigh, attorney from Markey & Walsh in New Bedford, Massachusetts. Okay, as some of you may recall, I was here at a number of different prior hearings relative to a variance on this property. The reason we're here tonight, as the chairman read, is a zoning denial letter was sent out, I think in July. The building commissioner responded with that letter on August 6th, citing the fact that despite the fact that there was 2 previous zoning enforcement officer positive determinations, the lot was held in common ownership. Not 2 days later, the Affordable Housing Act was passed. Now, I did not know that this was coming or part of that act. Part of that act, Section 10 of that act, allowed for further protections against, let's call it the merger doctrine. That materially changed, that would have materially changed the way we approach this. The reason I'm here tonight is because that new state law that's in effect now allows for a lot such as 96 Bryant Street to be a buildable lot as long as the house that's put on it is no larger than 1,850 square feet with 3 bedrooms. The reason I'm here tonight and we didn't withdraw is because all the effort in the plans that had gone in prior, engineering, site plan, building plans, was for a building that was slightly larger at 1,952 square feet. Now, we already had the administrative appeal filed, talked to the client. The idea was come here today, and for a number of reasons, I have a little slide. It doesn't work, but I can read it off. And you've heard a lot of this before. I think it's a reasonable request. I'd ask that the board just keep an open mind when you hear what I'm about to say. You may recall from previous hearings the history of this lot. 1968, it's basically a family farm that's broken out into several parcels. One of them was conveyed to Jim's father, Tom. And at that time, and this is important, it was in the general residence district, which only required 15,000 square feet of lot area and 100 feet of frontage, which it has. 1971, zoning is changed to SRC, and then the following year via town meeting, the zoning's changed again to SRA, which it is in right now. 1996, Jim's father, Tom, applies for a variance for this lot. In the minutes of the variance, he says specifically, I'm here to achieve a buildability determination so that I convey this to my son. Okay, he kept it vacant the entire time. That variance is passed in July of 1996. The very next week after the appeal period ends, he conveys it to Jim. Jim's held it in ownership since that point. It remains vacant. The idea was always to make it a buildable lot. Life, like we talked about previous hearings, life gets in the way, hasn't been built on. But Jim did take 2 steps to sort of make sure that this is a buildable lot along the way. 1998, he gets a positive building determination letter from then Commissioner David Silvera. Okay, he relies on that. 4 years later, in 2002, another positive determination letter from the same building commissioner, David Silvera. So here's Jim. He's got the variant. He's just a normal guy, works on the docks. He's got this lot. He's waiting. It's going to be part of his retirement. He's got the variance, and we know here that the variance is lapses after 1 year. But he's got that variance in his hand. He's got the 1998 letter from David Silvera in his hand, and he's got the 2002 letter from David Silvera in his other hand. So fast forward to 2023, when he approaches Markey and Walsh, we start the process. I went through a variance application process with this board. We withdrew without prejudice. I think putting our heads together, the best idea was to approach it this way, asking Commissioner Bassett to approve it consistent with previous determinations. And then I would add that with this very recent addition to the Affordable Housing Act, which doesn't exactly apply to what he's proposed here. I can't lie. He doesn't have, we wouldn't be here. It's slightly larger. The building plan that we have in hand is 1952. So it's about 100 square foot over. But it would not comply with the law. So I'm here tonight. I'd ask you to, like I said, keep an open mind and put these, all the factors that I've already described, weigh them, and I would hope in favor of my client. In addition, over the years, his father went out and had a betterment done, and the lot is tied into town sewer. He's been paying taxes on this lot now since 1996. And truly, he's just looking for this to just once and for all be declared a buildable lot. I think that's it.
Right? Bob, you have any questions?
Not at this time, no.
Halim?
Just one question. So the proposed house is 1952, 1,952. How many bedrooms?
Over three? Three. Yeah, it's over three.
Over three?
Yeah, it's a minimum of 3 bedrooms that you have to have in order to,
No, I understand.
Okay.
What, you have plans for the 1952 house. How many bedrooms do you have on that plan? Is it 3 or 4?
can I,
Sure.
Sorry.
Yeah,
Yeah.
no, it's okay.
yeah,
You can approach.
just introduce yourself.
Oh, I just want to talk to you. Right. You know what I mean? Right. Okay.
Three bedrooms?
3 bedrooms, okay.
Anything else, Halim?
No, no, at this time. Thank you.
Faria?
I just had a couple of questions. I'm a little bit confused. Is how much frontage is there on this lot?
I believe it's 100 feet.
110.
110 feet? And where did the merger come in? I just heard testimony that this lot was conveyed out to the son.
It was.
So where do we get the opinion that there was a merger in the lots? Was
Because-
it prior to the conversion?
It was prior to the transfer
Transfer?
between, it was at the time that his father, James' father, actually divvied up the lots. He conveyed one to his son, James. But the problem was, is over time, the zoning requirements had changed. He says it was Residence C at some point. I wasn't aware of that part, but I know it went from general residence, he claims Residence C, and then Residence A, which is where it's at now.
All right, but the question that I had was, apparently, they got a variance for the lot because it was undersized?
Or at one point in time, yes, they got a variance because it was undersized. It was a variance, it was a determined, it became before, not us, but a different board, but it was
I
a zoning
understand
board.
that.
And it was, variance was granted. And then subsequent to that, I believe there were 2 other opinions made by building inspectors of our town who determined that the lot was still buildable. This came before us, I'm not sure if you were here, they came before us once before for a variance.
I remember
And
that.
given the fact that it was an undersized lot, and we have sort of a certain, I'm not gonna say a position, but we have not granted an undersized lot in quite some time. At least since my tenure here, I've never seen us grant variance for an undersized lot. But I felt that this one was due some special consideration. And I think we suggested, I don't know if it was just myself or myself and Halim, suggested that maybe they come back to us with an administrative appeal possibly. Because in that respect, we could rely on the opinion of the prior building inspector. We always want consistency. That's one of the things I think we strive, at least I strive for as a chairman of this board, that we want some consistency. And this gentleman had consistently been told, at least on 2 occasions, that this was a buildable lot. And I think there was some reliance, some significant reliance placed on him on those representations that he had a buildable lot. And unfortunately, things have changed. There are other couple characteristics, in my opinion, that also, lend to giving consideration for this. Is one, this is, I believe, delineated by a stone wall between the 2 properties. So this is a stone wall that's been in existence probably for a lot more than 50 years, might even be 100 years, that delineates this. In addition to that, there's a separate driveway opening for the way. I've driven by there to look at this. There's a separate driveway opening that will serve just for this lot. It wouldn't serve any other lot. And there's a structure there. There's a shed that's there. And there's some case law that establishes that if there's a structure on the property, you can do a division of the property and it not be a subdivision if you have two structures. And I believe that might have been the situation prior to the building of the house that was next door. So I think these are also variables that play into the consideration that we can have as a board about granting the relief that they're seeking. The only thing is the wrench in this, which actually works to his benefit, so if this board were not to render a, if we were not to grant their appeal, so to speak, and basically, I'm not gonna say nullify, but I guess the proper term would be, we'd adopt the opinion of the prior building inspector that the lot is buildable, and reach an opinion that the lot is a buildable lot, given the circumstances. And if we do that, he'll be able to build the size of home that he seeks to build. But what's happened is, the governor has passed into law under the Affordable Care Act, and I haven't read through it as well as I'd like to read through it, but I've perused it, and it does allow for, even though there's common ownership, if there's a lot if a lot that was held in common ownership is at least 10,000 square feet, and I think 100 feet of frontage, it's a buildable lot. Is that your understanding?
That's right.
Is it 10,000 or 15? It's 10,000. 10,000 feet and 100 foot of frontage is a buildable lot. And that's something we're going to be confronted with in this town, and not just our town.
75 feet of frontage.
75 feet of frontage, okay, that's what it is, 75. 100 is in general residence district. It's 75 foot of frontage. And that's been enacted. Now, exactly when it takes effect, I'm not certain about it, but I think it's in effect now. I spoke to the building inspector about it. So even if we take no action on this, they're still able to build on this lot. And that's what drove me to want to consider this, is the fact that I didn't want this to be a situation where this gentleman had been, he had been conveyed this, expected that it would be buildable, was told by building inspectors on more than one occasion that it was built, by a building inspector on more than one occasion, that it was buildable, and then now it's not. I just certainly think it calls into question, you know, some of what people will perceive of, you know, how we work collectively as a board with the building department.
Well, my question to you, Mr. Chair, is that if we take, this is an appeal.
This is an appeal.
If we grant the appeal,
Yes.
what we're saying is it's a buildable lot.
Well, what we're saying is that we don't agree with the opinion of the building inspector, with all due respect to him. We don't agree with the opinion of the building inspector, and therefore, we would determine that it would be a buildable lot.
Okay, and he's relied through other building inspectors, these people have relied, they've been told that it's a buildable lot, and they've relied on the town of Dartmouth that that's a buildable lot.
Correct.
Now, if we deny this appeal, he still has a right to build a house, but it's gonna be smaller,
That's correct.
all right? In my opinion, in my humble opinion is, I don't think the town of Dartmouth should be telling somebody that you can't build a house that's gonna be maybe 100 square feet more. If these people relied on the town of Dartmouth, which they're here, and I believe the gentleman here, the attorney that's representing them, that there's a reliance by the town of Dartmouth, not once, if I understand it, twice. I think you rely, that's why we have building commissioners and inspectors here, that you rely on them, and you plan your future for that. Now, all of a sudden, are we gonna be arguing about, is it 100 feet we're arguing about? If it,
Well, it's the square footage, and the square footage, there's a significant,
how much, what's the square footage that we're arguing about?
1,200.
1,200 square feet?
and also the frontage is short. The frontage is short by 40 feet.
But I think the gentleman said, the attorney said there's 110 feet frontage?
But in a single residence A zoning district, it's 150 frontage, so we're short 40, and also the square footage.
Right, but that wasn't the case. The frontage was okay when he was told it was a buildable lot.
Correct.
I built a house in Dartmouth many, many years ago, and at the time, we had to have 100 feet frontage, and I had 96-foot frontage. I came before this board, wasn't you people, because it was 100 years ago when I got the variance, although Michael looks like he's been here 100 years, but off the
Thanks.
record. But in any event, I had 96-foot frontage. I built the house, and I'll tell you, I didn't want to cut the grass. I had so much grass, but my lot was bigger than every other neighbor's lot on Wilson Street. And I feel badly for these people that they've relied on this, and now we're arguing about the square footage. That house is not going to disrupt anybody in this town, not going to disrupt anybody in Massachusetts, and we're here deciding on their faith as to what. I think we should just, this is a buildable lot. They relied on the town of Dartmouth. They spent money, they've done things here, and Mr. Chair, what you said too, the reliance on, there's a shed there, there's a driveway, this,
I share the same sentiment as you, but the problem is we can't just make these decisions based on a whim here, right? We're making decisions that certainly I don't think I've ever handled an administrative appeal. Maybe we had one once before. So I'm always cautious that if we're gonna make a decision, that, viewers at home, anyone else who's considering doing something, understands where we stand on this. And this is a very unique situation, given that there was a variance that was previously granted by our board, and like you said, there was 2 other zoning determinations by a building inspector that are different than what's being said today. And I'm not saying that our building, and I want to make it clear to everyone, even in the audience, viewers at home, I'm not saying that our building inspector, our current building inspector, has made any error in his opinion. All right, I'm not saying that. All I'm saying is that this was one in which there's inconsistency. And the fact that there's inconsistency certainly raises issue to me to want to give this consideration. I think that's one of the reasons why we had suggested at the last, was there not a suggestion made at the last hearing that you consider coming before us in this method? Now, the thing is that moving forward, I don't know if we're going to find another situation in the next whatever years that I sit here, or anyone else sits here, that we're going to have such a unique set of facts where someone has the level of reliance that this individual may have had. So I guess what I'm trying to say is, first, I share your sentiment. 2, I'm just cautious about moving forward and how we handle it. And I'm only one person, right? We've got 2 other members here that are voting members here tonight that obviously I want to hear from them and make sure that they feel the same way about it.
Mr. Chair, I agree with you wholeheartedly, but I think what you said originally is what this board has tried to, since I've been here, and I know you guys have been here longer than I have, consistency. That's the key. I'm not saying that the building commissioner made a mistake. I'm just saying these people relied on the town of Dartmouth. And in that reliance, you go forward with your future here, and for all of a sudden somebody said, oh, now it's not a buildable lot, and we're here arguing about square footage, really is what it is. And as I said, the size of the lot, the fact that they relied on the town of Dartmouth is very important to me, because that's where you go to. You go to the town, and if you're deciding, and most people, building a house is your most important investment in your life. And these people have a lot, they relied on the town of Dartmouth, and all of a sudden now they find out that it's not a buildable lot. And they're here in the legal process, and if I had a vote, which I don't have a vote, but my recommendation is that I think that we should grant this appeal, that the equities are with these people.
Thank you.
Mr. Chairman,
Yes?
a question to you. If we were to grant this request, how does that impact setting a precedent?
Well, it does,
We don't get many of these cases.
no, we don't.
And this is probably a standout, a different type of case for us. But does it affect the setting of a precedent for us as a board?
It would, to the extent that if you had a similar case with similar circumstances, then I think we'd have to look at it from the same light that we're looking at this one.
Okay.
But the expectation that we're gonna see something like this again is probably not that great.
Pretty low.
It's
Yeah.
the probabilities are probably pretty damn low. And what Walter, Attorney Farrier, has raised, that was a sentiment I felt the last time they came before us. And I was really concerned about the variance, but I thought that there may be another avenue here, and I think their counsel has seen it, and their counsel's presented it. So if the voting members are inclined to grant it, then what I would suggest is we give them an opportunity to put together a decision for us, one that's going to be succinct, because I wanted to state all of these facts, what you just alluded to in your presentation, and in addition to that, also the variables that I had mentioned about the fact that there was a shed in the stone wall, that all laid out, and then we would review it, and we could take a vote on that. But before I do that, this is a public hearing, so I want to give an opportunity, if there's anybody in the audience, because this is people I notified, abutters I notified, if they have any concerns. So I'm going to ask anyone in the audience, if you'd like to speak either in favor or in opposition to this petition, if you could come before us and stand at the podium and voice your concerns.
Hi, sorry. I definitely are for them.
Okay, so you
Absolutely.
support the petition, okay. Could you state your name and your address, please, because we
Yep.
need for the record.
Yep, my name is Susan Ashley. My address is 37 Gifford Ave in Dartmouth.
All right. How far is that from Bryant Street, this location?
I don't even,
Oh, you're not, no, okay. But you're in the area, you're a town resident, and
yes,
you support the petition?
yes.
I respect that. Thank you.
Thank you.
All right. Anyone else would like to speak either in favor or in opposition?
My name is Elliot Dubem. I'm from 39 Gifford Avenue. I'm in favor of that due to the supporting information from previous family members that have held down to this generation.
Okay, thank you. Anyone else?
Paula Flannery, 100 Bryant. My property is adjacent to this lot we're talking about. I'm Tom Lemier's daughter. Jim is my brother. And I want to thank the board, for the way they're considering all the details, all the new information, and trust that this will go forward. It will be a buildable lot. Our neighbor, who is going to be building on this lot, hopefully, is going to build the house of his dreams, the size that he wishes, and we can move forward from here. Thank you.
Thank you. Anyone else? All right, so there appearing not to be anyone else, either in favor or in opposition. So are you inclined to grant, based on, if we had a decision that was put together that set forth the findings that were alleged by the petitioner, also some of the ones that I also had alluded to, would that be something we'd be willing to consider to move forward on in the affirmative for the administrative appeal?
Yes, I'd be inclined to approve this variance.
Same, Mr. Chair.
So Attorney McVeigh, if you could come to the podium. So we can keep this on a short time frame. So we could put it on for next hearing date, which is October 9th.
It's my wife. My wife and I will be away for our anniversary.
All
Sorry,
right, so
I'm sorry.
you want to do the
Sorry,
following,
Jim.
the following 2 weeks from that? We don't have anything else? All right.
If I may, Mr. Chair,
For the, yes.
It doesn't have to.
He wants to say something, hold on.
we can have an associate. I could probably get John, I hope, for this client, absolutely.
Certainly. There's,
Mr. Chairman, just so you know, I won't be here on the 9th.
well,
He's
Walter's,
not going to be here on
what is it, excuse me? Oh, you're not going to be here either, are you?
October, have Medford Planning Board.
You just moved the meeting?
Oh, this yours?
Zoom?
No.
Well, we have Attorney Farrier here, right?
Do we want to take it out of, and come on the 8th and just have?
Just come in for that on the 8th?
just on for the-
Gone for that week, sorry.
Well, you do have an associate,
Oh, I
right?
can-
Absolutely.
The 9th.
It's all right, you can put him to work.
He'll come. Yeah, he'll come.
All right, so let's see what I got here.
Excuse me. I gotta be quiet. I want them to be quiet.
All right, October 8th is a Tuesday.
I can't do Tuesday.
You can't do Tuesday.
I have another meeting.
All right, so the only thing is, Bob, you're not going to be here the 9th?
I leave the 8th, I won't be back till the 22nd.
So you're leaving, you're not available the 9th? And well, we got Dr. Agai and we've got Attorney Farrier that are available on the 9th.
No, thank you, I have nothing. No addition.
What is it, are you recusing yourself on this one, Doctor?
No, he just misunderstood. I think it would have to be Dr. Agai, because he's been here with all the other.
No, no,
Well, this is a
the
new
first
one.
case.
This is an
first
appeal
appeal.
that started, yeah.
So this is a first-time case. So we would need Dr. Agai and Walter Farrier.
Right.
Okay?
All right, you'll be available on the 9th, Doctor?
I'll bring him.
All right. So we'll put it on for the 9th. Obviously, it's just going to be, if everything rolls smoothly, there's not a lot to present other than the document, and we'll read it into the record.
Be here for October 9th?
Right, so you agree to continue the matter to the October 9th, correct?
Yes.
All right, so gentlemen, I'll entertain a motion to continue this matter to October 9th.
Mr. Chairman, I make a motion that we
Continue.
continue the application for AAPL 24-1 until October 9th.
All in favor?
Aye.
Aye.
Aye, the ayes have it. See you on the 9th.
Postpone it up to October 9th.
Yes.
Oh, yeah, that's fine. That's good, yeah, yeah, yeah. You're welcome. All right. Moving on to the second matter. On tonight's agenda, special permit ZSP 24-8. The petitioner is Oscar Flores. The owner is Elio and Christine Dobain. The subject property is located at 39 Gifford Avenue, map 166, lot 91. The property is located in the General Residence District, and this case was legally advertised on September 5th and September 12th of this year.
Make a motion that we waive the reading of the butters list.
Second.
All in favor?
Aye.
Aye.
Aye, the ayes have it. The petitioner is seeking a special permit to bring a water line to a pool house. Let's see what we've got for decisions here, or determinations. We have a letter from the building inspector. It's dated April 19th. It says, "I've reviewed your application." It was sent to Oscar Flores. And it says, "I've reviewed your application. At this time, your proposal cannot be approved due to non-compliance with current zoning regulations. Proposed 20-foot by 20-foot pool house with water line per zoning bylaw 10.3B, accessory buildings or structures with kitchen or bathroom facilities, accessory buildings or structures within which a kitchen, wet bar, bathroom, or any plumbing is installed, such as but not limited to cabanas, garages, or studios. Such an accessory use is allowed by special permit granted by the Board of Appeals if the following requirements are met. The Board of Appeals determines that the accessory building or structure will not be used as an additional residential unit on the property. The Board of Appeals shall determine through a review of submitted building plans that the nature of the proposed plumbing, wiring, or other utilities is not proposed in such a manner so that the accessory building or structure could be used or converted into an additional residential unit. And two, if a special permit is granted, there can be an inspection once a year after notice to the owner to determine that the accessory building or structure has not been converted into an additional residential unit. Conversion will result in the revocation of the special permit after a public hearing in accordance with Mass General Law, Chapter 40A. Your application is being denied under these sections of the zoning bylaw, and the subject property is located in the general residence district. And it's from the zoning enforcement officer. That's the first thing. Let's see what else we got. I've got some comments from the Conservation Commission. It says the project work appears outside of the riverfront area immediately to the south. No conservation issues here. And that was from Mark Garrett. And we've got the DPW compliance with the following DPW regulations, which is their usual and standard regulations. All right, so at this time, I'm going to call upon the petitioner or their representative to come forward and state your case.
Hello, my name is Oscar Flores. I'm the person who submitted the special permit for this property. The owner is here, is Elio Dobain. And basically, as we show in the plans, I mean, the purpose of this structure is going to be a pool house that is going to support, of course, the pool. So if you see the plans, there is no evidence or design that suggests that it's going to be a livable area. Therefore, this is, to support the pool and just make it more safety, healthy, like to just keep it outside the main residence, so the kids can take a shower, clean, and everything in the pool house, and keep it like a separate structure. That's basically the reason.
Okay. We've seen these before, many times. The only thing that I always have concern with is that the open area is labeled like a living room. So I always want to make it clear, Mr. Dobain, you have to understand that this cannot be used as a separate living quarter. You understand that, correct? That's what our zoning bylaw says now. but there's also a new bylaw that says something different about structures that, it's not a bylaw, it's basically a state rule that came down that the governor's recently signed that changes that a little bit. But based on the bylaw that we have here before us now, it can't be used, and the town is able to on a yearly basis, and that'll be one of the conditions, if we were to grant this, that we impose, is that they can inspect it once a year to determine that it's not being used as a residential dwelling. You understand, a habitable unit. All right. So this is a public meeting. I do, well, is there any questions of the petitioner on this?
I have none at this time, no.
I have no question, Mr. Chair. It's
Varian?
straightforward.
I have none.
No,
Doctor?
thank you.
It's pretty straightforward, I agree. Is there anyone in the audience that would like to speak either in favor or in opposition to this petition? We have a gentleman. You live at Gifford Road, or Gifford Avenue, right?
Yeah, I'm Peter Ashley Jr., 37 Gifford Ave. I'm in favor of it.
How far are you from this petition?
Right next door.
So right next door?
Yeah.
All right. Thank you. Is there anyone else that would like to speak either in favor or in opposition? Did not appear to be anyone else. So what we do typically is we don't close the public hearing. I put together some proposed findings for the board to consider. We review those. We leave the public hearing open in case there's anything that needs to be added. And then after that, we'll close the public hearing and we'll render a decision.
That's good.
All right, so let me pass these along.
Thank you.
Third, there's another hearing.
All right, findings, gentlemen. The subject property is located at 39 Gifford Avenue, Dartmouth, Massachusetts, and it is also known as Assessors Map 166, Lot 91. The property has been owned by Elio DeBang and Christine DeBang since November 10th, 2022, and is located in the general residence zoning district. The petitioner seeks a special permit to bring a water line to a proposed 20 by 20 foot, one-story pool house with a kitchen and bathroom with a toilet, sink, and shower. Petitioner seeks relief under Article 10, Section 375.10.3B12, special permit uses wherein accessory buildings or structures within which a kitchen, wet bar, bathroom, or any plumbing is installed. The board finds that after review of the submitted plans, that the nature of the proposed plumbing, wiring, or other utilities is not proposed in such a manner so that the proposed structure could be used or converted into an additional residential unit. And the board finds that the addition of the pool house will not be detrimental to the neighborhood and is in harmony with the general purpose and intent of the zoning bylaw. And then we have the usual conditions, which are you're gonna get all permits from all town boards and approvals, and also the one that makes it subject to the inspection. You have any questions about that?
No, I don't
Mr.
have a
LeBay,
question.
any questions? Good. All right, so at this point, I'll entertain a motion to close the public hearing.
Motion to close the public hearing?
Second.
All in favor?
Aye.
Aye, the ayes have it. So gentlemen, what's your pleasure?
I make a motion that we approve application special permit ZSP 24-8 with the findings and the conditions as stated.
Second.
All in favor?
Aye.
Aye.
Aye, the ayes have it. Congratulations. All righty.
Easy.
Moving on. Next is special permit 24-14. The petitioner is John Romanelli. The owner is Iris Begley. Subject property is located at 9 Cedar Dell, and it is map 41, lot 6-3. The property is located within the single residence B and Aquifer Zone 3 district. The matter was legally advertised on September 5th, 2024, and September 12th of 2024.
Make a motion that we waive the reading of the abutters list.
Second.
All in favor?
Aye.
The ayes have it. The petitioner in this case is seeking a special permit to construct a 16 by 32 in-ground pool and pool apron patio in the rear yard of the existing property. Let's see what we've got for comments here. We have the building inspector, and the letter was sent to Mr. John Romanelli dated August 6th. Says, I've reviewed your application. At this time, your proposal cannot be approved due to noncompliance with current zoning regulations. Applicant proposes to construct a 16 by 32 foot in-ground pool and pool apron / patio in the rear yard of the existing property. This property is located in the Aquifer Zone 3, currently at 15.6% lot coverage, seeking to increase to 18.3%, A special permit is required per 375-28.6 to increase the lot coverage. Your application is being denied in the following sections of Dartmouth zoning bylaw, 375-28.6, special permit uses. And it says, unless a protected and lawful use or an exempted use, the following shall require a special permit from the Board of Appeals. The expansion or modification of a non-conforming use, on-site liquefied petroleum gas, and it goes on to say, and it has to do with the percentage of lot coverage within that code. There's a lot of inapplicable provisions that are listed here that really don't have direct relevance to what's before us. And it goes on to say that the property would require a special permit in order to be able to allow the type of expansion that they're seeking to conduct on this premises, and the property is located in a single residence B zoning district. All right, so let's see if there's any other comments. I've got two comments. I've got one from the Board of Health. It says the pool permit was approved by the Board of Health on July 18th of 2024, and we got the standard DPW compliance with the following DPW regulations. All right, so at this point in time, I'm going to call upon the petitioner's representative, who appears to be already at the podium.
Thank you. For the record, Terry McGovern from Zenith Land Surveyors, pinch hitting for John Romanelli, who is still coming home from the field, and with me are the Begleys, who live at 9 Cedar Dale. Essentially, the issue at hand is the lot coverage. The lot was created as part of a 40B subdivision in 2006. At the time, it was...
Did you say 40B?
It actually, yeah, it was created as part of the 40B subdivision, and then was modified in 2011 to reconfigure the lots and have less,
You remember this?
less lots, and some parcel swaps took place at that time. Currently, the lot is configured, holds 40,420 square feet. The existing lot coverage is 15.6%. The pool in the apron will provide for a square footage increase of 1,118 square feet, roughly 2.7%, which would bring it up to 18.3. Again, it's something that if they basically were outside of the water or the aquifer protection district, they would be allowed up to 50% coverage. If they had a conforming 80,000 square foot single-family lot, they would only
Sorry,
be...
can you say that again? Can you just retract a little bit about where it's within the aquifer zoning district, right?
Yeah, we're within it. If they were outside of it,
You're outside. Okay.
outside of it, they'd be allowed up to 50%.
Okay, I didn't hear the outside.
And if they had a conforming 80,000 square foot lot, they would only be at 9.25%, even with the pool. They'd still actually have a little bit of room to put up another small shed or something of that nature. Essentially, the pool's being placed behind the house, as shown. Grading around it will be 3-to-1. We're providing an erosion control barrier, and we're pretty familiar with addressing DPW's comments, but until the special permit issues, it's putting the cart before the horse before we go ahead and address those.
Is that it?
That's it.
All right. So, Helene, let me ask you. I'm surprised that the DPW is not asking for some type of
Well,
recharge.
this is residential,
Well, that's why, okay.
I think, and also,
Okay.
that probably have to go back anyways.
All right, so I've been presented with 1, 2, 3, 4 letters. I'm going to read one because they're all the same. As far as, they're not from the same individuals, but they all have the same message. And it says that, "Dear members of the Zoning Board of Appeals, I'm writing this letter to support Iris and Edward Begley's application for an in-ground pool at their property at 9 Cedar Way in Dartmouth. We are the direct abutters at 22 Cedar Way, Dartmouth, Mass. We have no objection to the proposed in-ground pool, and we encourage you to grant the variance for this pool." It's not a variance, it's a special permit, but we understand. And we've got one from 13 Cedar Way, basically asking for the same thing. This one is from Megan Tavares. The first one was from Heron De Silva. The second one I'm referring to is from Megan Tavares. The third one is from 10 Cedar Dale Way, and that's from Linda Freitas I can't make out Edward, I believe also DeFreitas. And the next one is also from 5 Citadel Way, and this one's from Christopher Casara. All right, so we'll place these in the file, gentlemen? Make a
Yes,
motion.
make a motion, we place those letters in the file.
Second.
All in favor?
Aye.
They're placed. Okay. So duly noted. So because of the fact it's residential, it doesn't necessarily require, but we have required,
I think they, if I'm not mistaken, they're probably after that, I don't know if they have to go for,
I'm not gonna make an issue of it.
No, the only, I mean, let me just have
It's
a
just that I-
question for the
okay, fair
applicant,
enough.
if you don't mind. So it's hard to tell on the plan in the back. So the deck and the patio, the pavers that are on the back, is those existing or the proposed?
The deck is, the deck in the back in here is existing.
Right,
It's small.
and the patio?
Yeah, this portion is existing, and then everything.
Are you just adding the pool?
Yeah.
And the pool and the 5 foot around the pool? Right. And I can't remember the zoning bylaws, so the area of the pool is considered impervious? Covered?
Yes, because not only the patio itself being concrete is impervious, but your pool has a liner or a concrete bottom, so
Okay.
water doesn't you don't want chlorine recharging into the ground, so
No, we don't want that.
it's
So you
considered
retain it,
impervious.
yeah, okay, all right, makes sense, but, yeah, I don't have any, I don't have
All right,
questions.
this is a public meeting. Is there anyone in the audience that would like to speak either in favor or in opposition to this petition? There appearing to be no one come forth to either support or object to this petition. At this point in time, we'll keep the public hearing open and we'll move to some findings.
Okay?
All right, gentlemen. Here you go. Here you go. Gentlemen.
I just had a question for you.
Sure, absolutely.
Do they have showers or whatnot, someplace to take showers after they cool?
This is not one of those situations where they're gonna be putting a pool house, to my knowledge, but I'll let them answer. So there's no pool house being constructed, no outdoor showers?
Over there,
Just the pool,
just only pool, that's it.
correct.
Thank you.
All right, so now, moving on to some findings, gentlemen. The subject property is located at 9 Citadel Way, Dartmouth, Massachusetts, and is also known as Assessors Map 41, Lot 6-3. The property has been owned by Iris Begley since August 25th, 2015, and is located in the Single Residence A and Aquifer Zone 3 districts. The petitioner seeks a special permit to construct a 16 by 32-foot in-ground pool and pool apron/patio in the rear yard of the existing property. Petitioner seeks relief under Article 28, Section 375-28.6, A12B, 1 through 8, special permit uses to increase lot coverage, which is presently 15.6% to 18.3%. Do I have those numbers correct?
Yes.
Right. The board finds that after review of the submitted plans, that the nature of the proposed 16-foot by 32-foot in-ground pool and pool apron/patio is proposed in such a manner that it would be appropriate to the natural topography, soils, and other characteristics of the proposed site. And finally, the board finds that the installation of a 16 by 32-foot pool and pool apron patio will not be detrimental to the neighborhood and is in harmony with the general purpose and intent of the zoning bylaw. Is there anything else you think we need, gentlemen?
No, I think that pretty much covers it, Mr. Chairman.
Do I have the wrong number on this, Helene?
Yeah.
I got the
it's
wrong number.
14, but it's okay.
All right, let's make sure. It is 24-14. What do I do with my pen? Here it is. That's a typo, we'll get that fixed. All right, so if there's any, gentlemen, I'm open to any comments on any of this.
No, this is straightforward.
It is straightforward,
It's
I
a
agree.
Modest increase.
All right,
It's not,
I'll entertain a motion to close the public hearing.
Motion to close the public hearing?
Second.
All in favor?
Aye.
All right. What's your pleasure, gentlemen?
I make a motion that we approve special permit ZSP 24-14 with the findings and the conditions as stated.
Second.
All in favor?
Aye.
Aye, the ayes have it.
Thank you very
Congratulations.
much.
Enjoy your pool. All righty. And moving on to the last hearing of tonight's meeting is special permit ZSP 24-9. The representative petitioner is Raphael Zelik of Zelik Design LLC. The owner is Rocky Choi, and it's 291 Flag Swamp Road. This was a case that was continued because there's a concern about some covenant that existed with the Board of Health, I believe. And we received a letter, we received an actual email, and it said that, as mentioned on the phone, I am requesting continuance from today's hearing to be able to complete the process with the Board of Health. Thank you. And it's from Raphael Zelik of Zelik Design LLC. So it appears they need a little more time. The only thing I'm concerned with is I want to make sure that we'll continue it to the next hearing date, just to ensure that if there's any issues, to ensure that they're also, this will be conditioned on their willingness to sign in a continuance form, if so required, to ensure that we don't go outside of the statutory time requirement.
I agree.
All right. So I'll entertain a motion, gentlemen.
Make a motion that we continue special permit ZSP 24-9 to October 9th, 2024. Is that the next hearing?
Yes.
Second.
All in favor?
Aye.
Aye.
Aye, the ayes have it. All right, moving on, gentlemen. We have the administrative portion of tonight's hearing. We have to review and approve minutes of August 21st, 2024. Any comments?
I don't have any comments, Mr. Chair.
I have none.
I have none. Gentlemen,
Thank you.
there being no comments, I'll entertain a motion. Yes, I looked at them.
Yeah, I make a motion that we approve the administrative minutes of August 21st, 2024.
Second.
All in favor?
Aye.
Aye, the ayes have it. We also have review and approval of variance case ZAV 24-13 for 4 Bakers Brook Road.
I have no comments, Mr. Chair.
I have no comments, Mr. Chair.
I make a motion that we approve the minutes of variance case ZAV 24-13 for 4 Bakers Brook Road.
Second.
All in favor?
Aye.
Aye, the ayes have it. Next is review and approval of special permit case ZSP 24-1, 1402 Tucker Road, which is a continued case.
I have no comments, Mr. Chair.
No comments, Mr.
Neither
Chair.
do I.
You want-
I make a motion that we accept the minutes for case number ZSP 24-7,
Right, is that, is it
24
7?
dash,
Dash 1.
One?
we
Tucker Road,
Yeah, 24-1 Tucker
the
Road.
next one. I don't know if that.
ZSP 1, I'm one ahead, okay.
Dash one, yeah.
Make a motion, we approve the special permit case ZSP 24-1 as submitted.
Second.
All in favor?
Aye.
Aye, the ayes have it. Review and approval of special permit case ZSP 24-9 Flag Swamp Road, which is also a continued case.
I have no comments, Mr. Chair.
No comments, Mr. Chair.
I make a motion that we approve the minutes for a special case ZSP 24-9 for Flag Swamp Road.
Second.
All in favor?
Aye.
Aye, the ayes have it. All right, gentlemen, so we're pretty much done. Is there any other business that you gentlemen would like to discuss?
I have
Before we
none.
entertain a motion to adjourn?
I have none.
I have none, Mr. Chair.
Anything?
I make a motion that we, I'm sorry?
He said he had none.
Oh, okay. I make a motion that we adjourn.
Second.
All in favor?
Aye.
Aye, the ayes have it. Have a nice evening.